Thank you.
Thank you.
Thank you, Mr. Cannings. Before we go to Mr. Dalton in the next round, I'm going to use my privilege as a chair to ask a question, and it refers, Ms. Bélanger, to the letter that you sent to the committee on December 14th regarding the cooling off period and the legal opinion that you sought. And in it, you said that the Charter gives a low threshold for infringement of the freedom of expression set out by the courts, and that the new cooling off period would likely be justified under Section 1 of the Charter. My question is there anything in previous court rulings or any other jurisprudence that would affirm what that Charter infringement would be? In other words, you sought this legal opinion. They said that it would be justified under this part, but not under this part. Are there any rulings that the expert legal opinion could refer to?
So I'll do a Charter analysis course 101, but the first test is to examine whether or not the rule as written infringes any constitutional rights. And when it came to freedom of expression, I am stopping people from lobbying for at least 2 years or a year, depending on the circumstances. The courts have said the minute you stop people from being able to speak, it's a very low threshold. The freedom of expression has been breached. Then when you go look at Section 1, is it justified? Is there a reason for this, and has it been crafted in a way that it minimally impairs? And so when the objective is to ensure that we have ethical and transparent lobbying, and that lobbyists do not lobby people that have a sense of obligation towards them, they have said that the legal opinion says that objective is clear, and the way that the rule has been crafted, we're not stopping people from doing political work. In fact, we're letting them do it, but if they choose to do so, there might be limits in who they can lobby afterwards, and it's only the people that they've helped get elected and their close associates. It also is limited in time. And, depending on the facts, it could be reduced. If somebody is your campaign manager and within a week you realize that it's not working and you let them go, they shouldn't be prohibited from lobbying you for 2 years. So there will be some facts that will be reviewed. And according to the opinion, it was crafted in a way that the court would likely simply say that it's justified.
Okay, so you also mentioned you went externally. Can I ask where you went for that opinion?
Well, it's actually in the public domain that I have a service contract with Goldblatt.
Okay.
That's in the public, Goldblatt Partners.
Goldblatt Mitchell, or it used to be Sack Goldblatt Mitchell. But
yes, exactly. Now, for the record, this is not a law firm that is registered to lobby, and they did a conflict of interest screen, so they're not in a conflict when they provided me with this legal opinion.
Okay. Thank you, Ms. Bélanger. We're going to go to Mr. Barrett next for 5 minutes. Mr. Barrett, thank you.
Okay, thanks very much, Chair. Appreciate that, and we'll have Mr. Dalton take the next set of questions. Commissioner, thanks for joining us again this morning. Can you give us an update about how many investigations that you've undertaken, a total, which is something that's available in your reports? How many have been referred to the RCMP, and of investigations and referrals to the RCMP, how many are ongoing?
I have referred, since my appointment, 11 files to the RCMP. I know that there has been one charge laid, and they have returned 5 files recently to me, which I haven't decided yet what I will do with that. So there's likely 5, 6 still ongoing. Files right now, I have probably 35 open files that are being looked at either at the preliminary assessment stage or at the investigation. It's always around 30 that we have ongoing. On what's in the news, so we saw with ArriveCan that we had the principals of a company called GC Strategies that were in almost constant contact with senior officials directly related to their field of business, and at one point even inviting, through, this is again in public domain, through access to information requests, even inviting the
most senior person with respect to the business they want to do in IT and technology out to an after-hours party, but constant meetings, constant invitations. Should that be considered lobbying? I mean, that is exactly what, if you walked out onto Main Street in any of our communities and asked someone, if you could find someone when it's minus 40, but on any other day, if you walked out and there was someone there and you asked them, does that sound like lobbying to you? They're going to say, yeah, of course that's lobbying. So,
yeah, well, the Lobbying Act has a lot of, I'll reframe it, not all communications with public office holders are considered lobbying under the Lobbying Act. It's considered lobbying by a lot of people, but the Lobbying Act does not cover all of the situations that are in with communications with public office holders. The Lobbying Act needs to be reviewed. I will not say it enough. The last review was in 2012. We skipped 2017. We skipped 2022. It needs to happen. And yes, contracting was not in my preliminary recommendations in 2021 because I simply had not studied it enough. But I have now, and I have looked at the regime in BC, and I do believe that there is a gap in the Lobbying Act with respect to contracting.
Right.
For orgs and corps, it's not for consultants.
Right. What about, we heard in testimony at another committee this week at Government Operations, it was reported in the media that the former head of McKinsey had taken a dinner with the now Deputy Prime Minister at her private residence. That firm has since done significant business in the excess of $100 million with the government. If there was a friendship there and no business was discussed, I think perhaps a reasonable person might say, well, that's not a lobbying interaction. But if the relationship is based only around business, and that seems to be the comments that Mr. Barton has made, even a dinner in a private home would be considered a lobbying effort.
Well, the location right now is not an issue, but it's the communication itself and whatever is discussed that whether or not it would be considered lobbying. Right now, if they're talking about getting a contract for an organization, that is not lobbying. From the perspective of the public office holder, I don't regulate that. So I can only regulate lobbyists that are registered. And when I say registered, I mean those whose name appear on the registry. There's a gap there. Organizations and corporations do not need to register until they've met the significant part of duty threshold. So there is a lot of communication that's happening that is not covered by the Lobbying Act right now. That needs to change.
Yeah, and with respect to that, that calculation, that percentage.
Yes.
Would you say that it's irrelevant whom is being lobbied? Like if a low-level member of a GR firm reaches out to a backbench opposition member on one occasion, then would that not be different than the chief executive officer of a multi-billion-dollar international conglomerate having direct communication with a member of the Privy Council? So do you believe that the Lobbying Act should treat those interactions
wrap it up
differently?
Quick answer, Ms. Bélanger, please.
Possibly. I haven't put much thought to that one. I think any communication with any of you should be transparent, and the level of influence or the level of decision-making power, not something necessarily that should be covered. I think they should all be. All communications should be covered under the registry. It should be transparency by default.
Okay. Thank you, Ms. Bélanger. Ms. Sachs, you have 5 minutes and maybe a little extra after Mr. Barrett's interaction.
Thank you, Chair, and thank you, Madame Bélanger, for joining us today. These are important questions and things that we definitely need to think about. The government, and I'm sure all my colleagues here, we're committed to ensure that lobbying and federal public office holders uphold the standards that are here, and asking these questions about integrity and also enhancing trust in the regime itself is something I value, as I'm sure everyone here. Previously, the rules surrounding gifts, favors, and other benefits were deferred to other federal authorities. Your office has mentioned that this creates challenges in administering and ensuring compliance with that rule. Can you just go into what challenges your office has been facing with this arrangement?
Yes. Again, since my appointment, 2018, I've received 12 phone calls about receptions, whether lobbyists can offer them or not. They know that even if I say don't offer it, that if you can accept it, they can do it. And so when people do call us and they say, can I offer a $25 breakfast, we usually will say yes. Or if they say, can I give a $50 breakfast, and we will say no. Whether or not that has any weight is zero, because if they offer you the $50 breakfast and you eat it and nobody comes to ask you that you shouldn't have, it goes unregulated. So it is very difficult to give advice right now when I have to rely on all the other regimes. And again, I repeat, it's not just yourselves. It's all public servants who are all subject to different, there is a code of values from the public service, but each department sometimes have their own codes. So it's challenges with respect to certainty. And then how am I supposed to find someone in breach of that rule?
Okay, so going in that direction, under this new
Regime.
proposed regime, you're essentially creating a $40 limit and an $80 annual limit.
Yes.
For gifts and hospitality, and it's a separated limit from what I understood. That this, is it separate, or is it that's the blanket amount for a public office holder in relation to a lobbyist per year?
It's in relation to the lobbyist. They can only offer public office holders, public servants, yourselves, senators, ministers, their staff, $40 per event, per breakfast, and we have asked for an $80 limit. In British Columbia right now, the annual limit is $100. And interestingly, in British Columbia, every time a lobbyist registered, they need to indicate how much money, the value of the gift.
And I want to talk about that because
Okay.
there's an incongruency now. So, it's not the same on all, what
Mm-hmm.
the ethics commissioner had. For example, we all received radon detectors and gave them back.
Yeah.
Because they were valued at $185. So we have this incongruency now. So if it's this amount, and this, it creates a confusing regime, I think, for many folks. Could you comment on the incongruency in the values?
It creates a
Confusion. There's
for lobbyists, it's going to be $40. There is no confusion, and it's $80 annual limit. If this committee thinks I need to raise it to $100, I will consider that. But it's not. There needs to be a signal that, and this is a signal that this is a reasonable amount. And in fact, it's more generous than what public servants can offer to individuals that they host.
Correct.
So I think the amount is, anyway, we came down with that amount, and I think it is reasonable. Not everyone agrees. Some have said that they should not be able to offer you anything at all. And so we came down with an amount that we view as being reasonable.
Okay. How much time do I have, Chair?
You have 45 seconds according to the clock, but with the soccer extra time, you may have a minute and a
We're feeling
half.
kind in -40 weather. I appreciate it. So I just want to move into, if I may, the 12-month and 24-month cooling off periods. As my colleague, Madame Nomadan, mentioned, with minority governments, election cycles might look a little bit different. What does this change from the previously defined? How did you get to 12 to 24 as opposed to what a full? Normally we thought a full election cycle here was 4 years. It may or may not be. I come from overseas where election cycles can be 6 months. So, I just like you to weigh in because this is the nature of government today. We may be going to elections more often. So.
And that's why the current rule will not have the concept of full election cycle. It's gone. And it was just in a guidance document, and it was a should, and it was really if you only had a very important role and significant interactions with the person you help get elected. We've gone away with full election cycle, and you're right, in the last years, it's been every 2 years. What we did is looked at regimes, and it's, as I say, when we talk about political work, there is really no regime. The only, with respect to political work, the only other cooling off period I could find was my colleague in Ontario, where it's 1 year. Unless, of course, there's an ongoing close relationship, then a different rule applies. But we came down with 2 years and a year, looking at the roles and the different regimes. And the list of the roles are examples. It really will depend on the importance, the relationship with you, the level of interaction. It'll be 2 years, and if it's less, it'll be 1, and if it's not much, it'll be